Hey, have you guys noticed how lawyers are always like the life of the party by just always being really focused on the minutia that no one else could give the slightest crap about?
You know, it's part of being a lawyer to care about the details. You know, we like to look at all sides, anticipate all the arguments, and let's face it, we just really like sounding smart.
Yeah, and those are good quality to have in lawyers. I mean, you know, maybe we're not any fun at parties, or at least I'm not anyway. I don't know.
Yeah, speak for yourself, Joseph.
Well, take qualified immunity, for example. Everyone's talking about it, but I know that you guys are going to try to tell me that it isn't as simple as people are making it out to be.
It's not as simple as they're making it out to be.
Cool.
Yeah, so on today's episode, we'll be discussing qualified immunity, how it started, how courts are applying it now, and why people are calling for its end.
Thanks for joining us on this episode of Fine Laws Don't Judge Me. Welcome to today's episode of Fine Laws Don't Judge Me, the podcast about the real life of lawyering. I'm Laura Temme. Allie is off this week, but
Good.
Are you going to let me introduce you, or are you just going to talk over me?
No, that's fine. Sorry.
Okay. I'm joined via the internet by Andy Leonati and Joe Fawbush. How are you guys doing?
Oh, just fantastic. I'm ready to rip and run.
You're ready
this
to go
week,
today,
guys. Yeah.
Yeah, I'm good too. It's a beautiful day outside, and we're ready to go.
Well, yeah, we do have a very interesting topic to discuss today, and it's something that I think all three of us have pretty strong opinions about. Qualified immunity it seems to come up in public discussion every once in a while, and now it's back in full force. It's back in full force, yeah. And so we wanted to talk a little bit about the background of it and why we have it and why maybe we shouldn't have it.
Yeah, and Allie is not here to rein us in.
Yes, it's going to get wild today.
I will say that I have been against qualified immunity for a long time. So
Before it was cool.
Before it was cool, exactly. Yeah. I was in on the early stuff. Yeah. But, you know, we are going to try to present both sides of the arguments. There are legitimate reasons for qualified immunity to exist.
In some form.
In some form, yeah.
Mm-hmm.
So we'll get into some of the details, but yeah, just off the bat, none of us are huge fans of the doctrine as it currently stands, and we'll get into why.
Mm-hmm.
Yeah, so I guess I'll just start here. I was doing some reading yesterday, you know, reminding myself of qualified immunity and government immunity, and the very concept of sovereign immunity comes from English common law, which was basically a concept that the throne had to give assent to being sued.
Mm-hmm.
It is not mentioned in our Constitution. It's just upheld by the courts. So
Correct.
I'm going to need you guys to convince me why this isn't the dumbest piece of crap legal doctrine that we have right now.
I mean, ooh, that's a big ask, Andy. You know, I think that, how do I want to say this? I guess the origins of qualified immunity aren't completely unreasonable. However, the way that it's developed as a legal doctrine and the way that it is applied today in particular, in my opinion, does a lot more harm than good. So that's what I would say right off the bat.
Yeah, I want to get into what Andy was talking about with the creation of the courts in just a second. But just for our listeners who maybe need a refresher or haven't heard of it before, qualified immunity offers liability protection for public officials and police officers when they're engaged within the scope of their employment. And so this means that police officers who are acting as police officers and doing their jobs typically have immunity from civil liability. So if they're engaged in a shootout, for example, and the victim of the police officer shooting sues, they can claim qualified immunity, saying that they acted within and in their role as a police officer, and that prevents the family of the victims from suing. But as far as Andy was talking about with the creation of the courts, The first time that the Supreme Court really entered into this subject was in 1967 with the Warren Court. And in that decision, the Chief Justice was trying to balance kind of the need to hold bad actors accountable, but then also this really kind of a pragmatic viewpoint that if police officers were worried about getting sued, they couldn't properly do their jobs. And so that's really where the doctrine came from, and that's the justification for it. The legal reasoning of that decision is a little thin, in my opinion. But I do think, the Warren Court is kind of known for doing what they thought was right. Some have called them more of an activist court. So I think their biggest concern was, and actually I'll pull up a quote here because I think it's kind of nice. The Chief Justice wrote that a policeman's lot is not so unhappy that he must choose between being charged with a dereliction of duty if he does not arrest when he has probable cause and being mulcted in damages if he does. And so that was kind of the pro and con of it for the Chief Justice.
Mm-hmm. Well, and something that I think is important in that particular case is that the plaintiffs were arrested under a Mississippi statute that was later found unconstitutional. And so one of the points that the Supreme Court made was that these police officers, it wasn't part of their job to predict that this law that they were upholding was actually unconstitutional. So at the time, they believed that they had probable cause under a statute that was valid.
Yeah, that's a great point, because in those circumstances, what the court decided is pretty reasonable and pretty pragmatic. But it's kind of from that little seed, it has grown into this huge beast that it is today. And that's really where the problem is coming from.
So thanks, Earl, but no thanks, Earl.
I don't even have a response to that.
Yeah, it sounds like classic cut the baby, both sidesism.
What?
King Solomon, come on, you guys.
I don't know. I know the story you're referring to. I just don't understand what you're saying about it.
It's like, well, we got to let cops rough people up if they're applying a law that's in place.
Yeah, well, and I think it's something that it seems like it happened by degrees as well. Just the more cases that came up involving this, the doctrine just got expanded more and more. There was another big case in 1982, Harlow versus Fitzgerald, where this sort of good faith dealing standard that we had before was replaced by a standard where the plaintiff can realistically only overcome qualified immunity if they can show that the government official had violated a clearly established statutory or constitutional right that they should have known at the time. And so it becomes this thing where the conduct has to be so egregious that it has to be completely ridiculous in order to overcome qualified immunity. And that's where a lot of the problems come in.
Yeah, I just kind of want to elaborate on your point, Laura, because the Warren Court had this good faith standard where the police officer in that case was arresting somebody in good faith, thinking that the person had violated the law. And 15 some years later, the Supreme Court took another case and said, oh, well, that good faith standard is too subjective. We can't use that anymore. Instead, we're going to create this completely objective standard, objective in air quotes here.
Yeah. I have some thoughts on that, but keep
going. And so that's really where it is today, is that the officer has to know that they're violating a clearly established right. So it doesn't have anything to do with good faith. It's just a matter of, is there an existing court case that has almost identical facts to the situation that the police officer is alleged to have used excessive force in? And if there's almost exact same facts, then the police officer does not get qualified immunity. But if there's any kind of a distinction that the court can make, whatsoever, then qualified immunity applies. And so it doesn't take into account, for example, whether the officer was acting maliciously or if there were racial overtones to the police officer's conduct. It's just a matter of, is there an existing court case in the back? And the real issue here is that, you know, a judge can manufacture a factual distinction for almost anything, right? I mean, so my issue is that this doctrine is applied wildly and consistently. I mean, it really does depend on the judge that you have deciding the case, because if the judge thinks that you should have qualified immunity, they can tie it to a previous case. If the judge thinks that you shouldn't, well, then they can manufacture whatever distinction they want, because no two situations are ever the exact same. You know, that never happens in the universe. So it's something that isn't necessarily applied consistently, and that's really kind of the definition of a bad legal policy, is that it's something that's arbitrary and inconsistent.
Yeah, so far the Supreme Court, I was reading about the 2002 case Hope v. Pelzer, which I'm not sure, but maybe maybe the Supreme Court's only kind of exception to the rule. And there we have corrections officers who disciplined a prisoner by handcuffing him to a hitching post for 7 hours with his hands above his shoulders in the sun. At one point, a guard taunted the prisoner by giving water to a guard dog in plain sight. There was no prior case that had confronted similar facts, according to the website The Appeal. And so the Supreme Court ruled that the officer's cruelty was, quote, so obvious that they should have had, quote, fair warning that their conduct violated the constitutional protection against cruel and unusual punishment. But that's a pretty, as the three of us are all in strong agreement that those circumstances are appalling and disgusting, but that's pretty far to be like, oh, for a judge to be like, oh, all right, well, I guess that's pretty bad.
Yeah, and that's why it's rarely used, because those were extreme cases. And you know, like, for example, there was a recent case out of the 11th Circuit where a police officer was chasing a suspect into a backyard, and he ran into a family with children in the backyard, and he told everybody to get down on the ground, which they did. So everybody was laying down on the ground. And then the family pet, a dog, came out into the yard, and the officer fired at the dog. The dog left. The officer was there for, you know, a couple of seconds. The dog came back, and it wasn't like attacking or anything, but it was kind of around in the house. The dog was basically worried about its family, and the officer fired again and hit a child.
Oh my God.
Now, so the analysis then in that case is, was there a previous case that was similar enough, and did it, you know, or was it so obvious that you shouldn't be firing at a dog with children around that it was excessive? And in a split decision, the 11th Circuit said that there was no similar previous case, even though there were some cases that were kind of factually similar, like a police officer had fired at a truck and hit a passenger in the truck. And in that case, he was not given qualified immunity. And so in that case, you know, you could see it being similar to the situation that with the dog, but the court said that they were too distinct of facts in order for it to be a clearly established right. And then two of the three judges on the panel said that it was not so obvious that it violated the Fourth Amendment right against excessive force. So in that case, the officer had qualified immunity, and the child who was shot, he didn't die, thank goodness, but he did not get any money.
So is it basically on the cop to then stay up to date on these applicable court rulings? So if they, like, is it on a cop during a traffic stop to say, oh, well, this sounds similar to when another cop in the 11th Circuit was denied qualified immunity, so I better not do this. Like, are courts giving cops like enough leeway to basically claim ignorance?
I mean, well, yeah, because if if they know that you basically have to have the same facts in order to not have qualified immunity, they don't really have a reason to keep up on any of it.
Oh, sweet.
Yeah, I mean, but your point is great because nobody reads federal appellate court cases except
for us.
Except for you two dorks.
Yeah. So no, that's a good point. And then, but that actually has been used as a justification by the Supreme Court for why they interpret this rule narrowly, because they argue that, police should not be forced to apply the law in new situations and just kind of be able to do that in a split second. Mm-hmm. And so that's why they say, okay, so we need to interpret it very narrowly so that there is clearly a situation that was like this where you can't use it. As far as that goes, though, I mean, like I said, police aren't going to be reading previous court cases. They may know certain circumstances under which they can use excessive force, or they can use force and when it becomes excessive. But yeah, they're not going to go through and try to read up on all the qualified immunity cases that have occurred in their jurisdiction.
Get to reading, cops. Yeah, and I saw that just last month, the Supreme Court declined to take up a case from the Ninth Circuit where the Ninth Circuit had ruled that two police officers in Fresno, California, who allegedly stole more than $225,000 in assets while executing a search warrant could not be sued over the incident. Although the officers ought to have recognized that the alleged theft was morally wrong. The Ninth Circuit wrote the officers, quote, did not have clear notice that it violated the Fourth Amendment. I mean, I don't know what to do with that.
Yeah, that's one of the things I struggle with this, especially when it involves constitutional violations, because I don't know what law is more clearly established in this country than the Constitution. So if you don't know, I don't know. I have a hard time wrapping my head around someone being tasked with carrying out the law and not knowing what is going to violate someone's constitutional rights.
Andy, I love that you brought up that case too, because I actually wrote on that on the Fine Law website. It's on our Ninth Circuit blog, so I'll plug that quick. Go check that out.
You can put it in the show notes.
Oh, I missed that. I missed that. I'm sorry that I don't keep up to date with everything you write, because I will put in a plug for the both of you. Both of you write exceptionally well on court cases, and make it pretty easy for a dope like me to understand them.
That's really nice, Andy. Thank you.
Yeah. But no, the facts of that case are just absurd. Yeah, I won't get into the whole thing that came through it, but that was another situation in which there seemed to be a clearly established right already in the Ninth Circuit, which would have put the officer on notice. But
not to steal.
Yeah, exactly. But the court really did kind of manufacture a distinction between the two cases. Basically, it involved whether the property that was stolen was mentioned in the search warrant. And so if you steal property in the Ninth Circuit as a police officer and you steal property that is not mentioned in a search warrant, then it is violating a clearly established right. However, if you steal property that is mentioned in a search warrant, then it's not violating a clearly established right.
Cool.
Yeah. Makes sense, right? Yeah. Of course.
Makes total sense. So if I could also really localize this for a second, the city of Minneapolis has entered into a temporary restraining order with our state's Department of Human Rights as part of an ongoing investigation into uses of excessive force in light of George Floyd's murder, that states now that chokeholds and other similar forms of physical restraint are banned. And so now, is that basically, would you guys think that since that's clearly written out in the restraining order, if a police officer here in Minneapolis were to use one of those restraints and it led to injury or death or anything like that, that they would not have qualified immunity, or is that not enough?
I would think that would be enough. Yeah. I think if the officers are prohibited by their own rules to not use chokeholds and they did something, then that would be something that they would not have qualified immunity for. I mean, one of the issues is that, of course, officers do have the authority to use deadly force in appropriate situations. And so there's nothing that says that an officer is violating the law or using excessive force just because a suspect ends up dead, because in some cases the use of deadly force is justified. And so that's why they go back to all these clearly established court cases. But in something where it's just prohibited to use, I don't think they would be able to get qualified immunity. So that's good.
Boy, what a relief.
I did also want to talk a little bit just because, we're ripping on qualified immunity as a legal doctrine. This is not to say that police officers are always in the wrong when something like this happens, or we're not understanding of the difficult jobs that police officers have. At least for myself, I understand the reason for qualified immunity to exist. And I understand that, police officers have to make split-second decisions in high-stress situations, and it's a tough job. So really my issue is with the legal doctrine itself. Like I said, I don't think it's a very clear law. It was created by the courts, and I just think it's applied inconsistently. So that's really my big issue. I don't want it to turn into like a, all cops use excessive force. And so I just wanted to clear that, and maybe you guys want to disagree with me on that.
I mean, I think I would agree with that for the most part. And I think for me, one of the things that bothers me the most about this as a legal doctrine is the sort of elimination of subjective intent. The courts don't look at someone's intent really at all in these cases. There was a 2015 case where police were in a high-speed chase. Several officers set out tire spikes on a couple different roads to try to slow down this suspect. And another trooper, without approval from his supervisor or any training in how to do so, decided that it was a good idea to post up, I think on a bridge, if I remember correctly, and try to shoot the engine block of the suspect's car. So he fires 6 shots at this car and, of course, doesn't hit the engine block. He hits the suspect 4 to 6 times. And immediately afterward, his first words to his supervisor were, "How's that for proactive?" in reference to earlier criticism he had received about not taking enough initiative on the job. But that statement was not part of the case, the civil case against him at all. It wasn't considered because this is supposed to be now an objective standard. And so that's something that I really struggle with in this.
Yeah, for sure. And boy, what a funny guy.
Right. Yeah. Like, just, are you serious?
Yeah.
I still, and just, I mean, I'm not baffled because I know how things work here. But it is baffling that we cannot just leave these matters in the hands of juries like we do for every other civil and criminal matter in this country. It's not like every jury is out there is going to be bloodthirsty to soak a police officer for every dollar in his bank account. There's going to be people whose sentiments lie elsewhere, which is he was doing his job the best way that he knew how. Mm-hmm.
One thing that I think is important to remember here is that in these civil cases, in the vast majority of them, possibly even 99% of them, it's not the restitution is not coming out of that officer's pocket. It's coming from the municipality.
from the taxpayers.
Exactly.
Yeah, officers are indemnified. That was going to be my exact point. And then, you know, and it's honestly, even if they weren't, you know, we can be honest about lawyers too. And, you know, if a police officer is going to be liable based on his or her salary, you know, they're not going to get sued because it's not something that an attorney is going to go after. Right. I mean, you know, I mean, maybe they would just for the benefit of
just
the
to prove a
family.
point. Yeah.
Yeah. But, you know, for the most part, it's not like police officers are going to pose a tempting target based on the money that they make. So see, we can be critical about attorneys too.
I'm proud. I'm proud of both of you.
Yeah, I'm very capable of of myself included.
So looking forward, I did also want to talk about kind of what's going to happen with qualified immunity, because obviously this is a hot topic of conversation. Congress has introduced legislation to end qualified immunity.
The House has.
The House has, yes. Which, yeah, I mean, we can debate how likely that is to actually become a law, but
Senate Republicans have said that is DOA in the Senate.
not too surprising. But there are movements afoot, is I guess kind of the larger point. And then even on the Supreme Court, you know, we've had both Justice Clarence Thomas and Justice Sotomayor, who couldn't be farther apart in terms of their judicial philosophies. You know, both of them have said we need to revisit qualified immunity. And Andy, I think you mentioned before, the court did deny cert for a couple of cases just a few weeks ago, but there's quite a few more that are on the docket. So they may very well revisit it next term. We don't quite know yet, but that's something to be aware of, because I do think that there is going to be pressure for the Supreme Court to take another look at this issue and maybe clarify things, amend things. I don't know how likely it would be for them to revoke it entirely, but it's definitely something to keep on the radar.
Yeah, I don't hold out a lot of hope, but they may clarify the statute more to make it the objective standard that the cop has to say out loud, "I am killing you because I don't like you."
Oh my God.
Well,
I don't even know what to follow that with.
yeah. I will say there is some justification for thinking that the Supreme Court won't, just because historically the Supreme Court has been very, very much pro qualified immunity. They tend to take cases that end up overturning a lower court who did not give the officer qualified immunity, and they rarely do the opposite. So there is reason to be skeptical. But on the other hand, you know, you've already got two justices who have publicly questioned the doctrine, which is pretty significant. So, you know, can they get three more justices on their side for one of these cases to clarify it? It's possible. Yeah. You know, so it's just something that we'll have to keep a lookout for.
Yeah, at the risk of sounding like a lawyer cliche that Andy would use, you know, this is a complicated issue, and it is constantly evolving. And so this is definitely something that we will need to keep an eye on to see how things develop going forward. We're going to take a quick break, and when we come back, I'm going to talk a little bit about someone whose reputation is so bad they couldn't win a defamation suit. Not having enough time to thoroughly review case notes in a brief before filing isn't an option. Legal professionals like you make the time, even if that means pulling long hours and late nights. Well, Westlaw Edge just released a new feature on Quick Check that will give you that time back. Quick Check Quotation Analysis is an at-a-glance report that shows differences between case quotes in an uploaded document and the actual case language on Westlaw Edge. Use Quotation Analysis to find weaknesses or inaccuracies in your opponent's documents that you could use to your advantage, and to ensure your quotes are error-free, because accuracy is everything. To learn more, visit tr.com/quickcheck. right, so for our last segment today, I want to talk a little bit about an interesting case that I recently wrote about. I feel like when we talk about defamation and libel cases, we focus a lot on whether or not the statements are true. And in this case, it was interesting to see a judge say, not only are these statements true, but everybody already knows, so why are you even here, essentially? And so a little background on this. Last year, former New York Met and now Emmy Award-winning broadcaster Ron Darling released a book called 108 Stitches, Loose Threads, Ripping Yarns, and the Darndest Characters from My Time in the Game, about his time as a Major League Baseball player. And along with some kind of wistful stories reflecting his time as a Major League pitcher, he included a story about an incident at the 1986 World Series where his teammate Lenny Dykstra shouted a series of wildly racist taunts at opposing pitcher Dennis, quote, oil can Boyd. So shortly after the book came out, Dykstra filed suit for defamation and libel against Darling, his ghostwriter, the publisher, everybody that he possibly could have thrown this at. He did. He claimed that the story forever labeled him a racist and caused him emotional distress as well as lost opportunities. So, Andy, I know you're a big baseball fan. Do you have any thoughts on this right off the bat?
Yeah, Lenny Dykstra doesn't need anyone else's help to make him look like a piece of garbage. He's done that enough on his own.
You sound like the judge in this case. So I found this case really interesting because in the book itself, Ron Darling doesn't say exactly what Dykstra said. And I mean, at the end of the day, it doesn't matter. He's made it pretty clear over the years that he's had all kinds of racist, homophobic, sexist, all kinds of word vomit coming out of him over the years that really, I don't think anything would be surprising at this point. Darling, didn't print any of what he said. He did say, quote, the stuff coming out of Lenny's mouth was beyond the pale. It was unprintable, unmentionable, unforgettable. I found this judge's opinion really interesting because he didn't really hold back and basically said what Andy just said is that, you don't need any help ruining your own reputation. And so the judge labeled Dykstra a libel-proof plaintiff, which is something that I had heard of, but I had never actually seen a case where this came up, and pointed out that Dykstra was infamous for being, quote, among other things, racist, misogynist, and anti-gay. And since baseball fans out there who are likely to buy this book most likely already know this, would you agree with me on that, Andy?
Yeah. Yes, definitely.
And so his conclusion was that the book couldn't do much to tarnish his reputation because he was already there. And so it's it's both, I guess, rough for Dykstra, but kind of entertaining for me to have a judge say that as a matter of law, everyone already knows that you're a hateful jerk.
Yeah, the 80s professional sports were vastly different than what they are now. Mm-hmm. However, Lenny Dykstra has just continued to beclown himself since then.
Ooh, beclown himself. I love that.
No, I love this. This has got to be the worst way to lose a civil case ever. It's basically, you're garbage, so you lose.
It just, as I was reading the opinion, I kept thinking about Gene Wilder in the Willy Wonka and the Chocolate Factory movie where he says, you lose, you get nothing. Good day, sir. Yeah, that's my story for the day.
Yeah, and 1993 me just absolutely hated Lenny Dykstra and his giant wad of chaw that was always making his cheek bulge out about 6 inches.
Lovely.
Yeah, that's a good image to leave our listeners with. Thank you, Andy.
That's all we have for today. Thank you so much for joining us for this episode of Fine Laws Don't Judge Me. Check the show notes for related content and lp.findlaw.com for more writing by me and Joe and
and not
shameless self-plug, and Andy as well. And if you have a minute, please rate, review, and subscribe, and we'll see you next time.